Okay. So today for our training, we have Rachel Haynes-Pinsker, and she's the Legal Services Manager for Pennsylvania Coalition Against Domestic Violence. And we have Karen Galbraith, who's the Training Project Coordinator from Pennsylvania Coalition Against Rape. And I will now turn the training over to them.
Thank you, Donna. This is Karen from PCAR. Welcome to the webinar. We're looking forward to an interesting couple of hours with you here this afternoon. Rachel and I are very informal in our training, so we really hope that if you have questions, you will feel free to ask them as we move along, and we will try to answer them as they arise because we want to be sure that everybody is understanding what we're talking about as we move along this afternoon. So again, as Donna mentioned, if you have questions regarding, sort of the content of the webinar, the things we're talking about, you need some clarification, please use the Q&A box to do that. And then as we move through and do the scenarios together, we'll ask you to put your answers into the chat box. And that'll become clear, I think, once we get to that point in the webinar. So again, my name's Karen Galbraith. I'm the Training Project Coordinator with the Pennsylvania Coalition Against Rape. And for those of you that are not familiar with PCAR, we are a statewide coalition that partners with 49 rape crisis centers across the Commonwealth to provide help, hope, and healing to victims and communities surrounding issues of sexual violence. So for our help portion of our mission, we provide training and technical assistance to professionals and community groups who work with victims of sexual violence and for those who are affected by sexual assault. The hope portion of our work comes in the prevention work that we do and the prevention work that we partner with our local programs to provide throughout the state. And then lastly, the healing comes from the great work that's being done through our partner centers all across Pennsylvania to support victims of sexual violence by providing free counseling and advocacy services, not only for them, but for their families and significant others as well.
Hi, everyone. This is Rachel Haynes-Pinsker, and I am the Legal Services Manager with the Pennsylvania Coalition Against Domestic Violence, otherwise known as PCADV. Very similar to PCAR, but there are 60 domestic violence programs located throughout the state of Pennsylvania that serve every single county in this state. PCADV funds and supports those programs. We also engage in a lot of training such as these. We do a lot of lobbying. We also provide extensive technical assistance. So if you have an issue with a victim of domestic violence and you're not sure, you want to talk to someone, you need some research, please contact us because that's what we're there for.
Okay, so we are going to spend the next few hours talking with you all about the various types of protection orders that are available in Pennsylvania. And we want to start off, though, by really being clear about, our understanding of and the prevalence of domestic violence and sexual assault, just so that we're all on the same page. And then we'll break into talking about the various types of protection orders, who's eligible for those different orders, what types of protections are available under each of the orders and each of the different acts that we're going to talk about today. We'll discuss the protection order process, how a person can go about obtaining one of these orders, and then talking briefly about, best practices when you are working with survivors directly.
Whoops, we went a little too far. Hang on, technical difficulty. New computer. Oh, there we are, perfect. So as you can see, this slide says 10 million women and men are physically abused by an intimate partner every year. That's an awful lot of people. So what the statistics tell us is that 1 in 3 women and 1 in 4 men have experienced some form of physical violence by an intimate partner in their lifetime. Out of that, 1 in 5 women and 1 in 7 men have actually experienced severe physical violence. And again, it's important to know with statistics, these are only the incidents of abuse that people actually report, and we know that for both sexual assault and domestic violence, they are vastly underreported crimes. So again, my hunch is that the amount of domestic violence that occurs is actually much higher. This is the amount that we know to be reported. What we also know is that although most victims of domestic violence are women, domestic violence occurs regardless of someone's gender, their age, their race, their ethnicity or physical ability, their socioeconomic status, sexual orientation and identity, religious beliefs, or background. It happens to everyone, unfortunately. Now, you may hear us refer to domestic violence as intimate partner violence throughout the training. They're one and the same. Intimate partner violence is a little bit of a more updated way of talking about domestic violence because it encompasses violence amongst all types of intimate partners. That includes family members as well as LGBTQ. So what is domestic violence? Well, domestic violence is a lot of things. But at its core, domestic violence is a pattern of coercive control that is rarely an isolated incident. It's really important to remember that domestic violence is all about control, and there are different methods to exert that control. So domestic violence includes the use of physical abuse, which I think we all understand. It also includes emotional and psychological abuse, and that is a part of almost every domestic violence situation. I used to represent victims of domestic violence in civil cases, and I had numerous clients say to me, I wish they just would have hit me. It would have been easier than being called fat and being called stupid and worthless. So that is a significant way of controlling someone who's a victim of domestic violence. Also, sexual abuse is a big component of domestic violence, except oftentimes victims don't want to talk about it because it's private, it's embarrassing, and a lot of victims of domestic violence, if you ask them if they've been raped, they'll tell you no, because that happens to people who are attacked walking home. It doesn't happen to them. But if you rephrase the question and say, well, did he ever make you do anything sexually you didn't want to do? The answer is yes. Well, sure, that's just the way it was. That's sexual abuse. Another huge component of domestic violence is economic abuse. One of the biggest questions you always get with domestic violence is, well, why didn't they just leave? If it were me, I'd leave. Well, if you haven't been allowed to work, or if you've been required to turn your paycheck over to your abuser, given no access to finances, been unable to save money for yourself, you can't leave. You don't have the money to do that. And when you couple that with having children who obviously have a lot of needs, it's not so easy. So again, that is a big form of abuse. The other thing to be conscious of is one method of abuse that is fairly common is when the perpetrator strangles their victim. Now, when you talk to victims about this, they're not going to call it strangulation because people just don't. They're going to say, they choked me. I got choked. Well, choking is when you're eating a piece of chicken and it gets stuck in your throat and you can't breathe. Strangulation is when someone manually presses on your neck and restricts your airflow. That's strangulation, but victims are not going to call it that. It's really important if you have a victim tell you that they were choked, that's a big red flag because strangulation is actually one of the biggest indicators of lethality in a domestic violence situation. Because when someone is being strangled, the batterer is literally holding that victim's life in their hands. It doesn't take much pressure or much time to strangle someone. So again, if you have a victim say that to you, you need to listen to that because, again, that can be an indicator of lethality. A big component in domestic violence is also stalking. Stalking occurs when someone engages in a repeated course of conduct that puts that individual in fear for their life. Stalking looks very different to everyone. Behaviors that you or I may not think of as stalking, the victim might think of as stalking behavior. I had a client once who, when she was in trouble with her abuser, he would leave her flowers on her car at work. And so she'd come out to her car after work and see a bouquet of flowers. And she knew that meant that when she got home, she was going to get beat. Now, if my husband left flowers on my car at the office and I came out and saw that after work, I'd know my husband did something wrong and he was probably going to get in trouble, but I wouldn't be frightened. That would, be a separate issue in my marriage. But again, for victims, depending on what's going on, that can be terrifying. So that's really something important to look for. And especially in this day and age with all of the technology and cyber stuff, cyber stalking is also another version of stalking where batterers like to stalk someone electronically. They like to post things on their Facebook page. They like to monitor their computer use and their email use. And again, at the end of the day, it is all about control.
Now, as we talk about domestic violence, and in a bit we'll be talking about sexual violence as well, it is just so important to remember that no two people will respond to a traumatic event in the same way. And when we talk about domestic violence and sexual assault, we are talking about traumatic events, and we're talking about things that are life-threatening or events that put someone in fear of their safety or their well-being. And so, as I mentioned, trauma impacts every single person differently. We know that people of different genders will respond to trauma differently. Based on past life experiences might impact how you respond to a traumatic event that happens today. And so you can never really anticipate how a person might respond, because almost anything is within the realm of normal when you're talking about responding to such abnormal types of events. But it's important to remember that when you come in contact with a victim, particularly in the immediate aftermath of either a domestic violence event or a sexual assault, that very often their behavior might even seem counterintuitive. It might not be at all what you would expect. On television so often, or just what we imagine as how we might respond in those situations, we expect that we might be very upset or crying or just, devastated by what happened. But what we know from working with victims and seeing the impacts of trauma is that very often that is not how someone might respond. They might, but it's also just as common for someone to present in a very unemotional sort of way. They could be telling you something very horrific that has happened to them and have a very flat affect, be showing very little emotion and just being very matter-of-fact about what occurred. And it's important to remember that those reactions should not be taken as an indication that something either happened or did not happen, because during a traumatic event, people experience many physical changes within their body. Chemicals are released within the brain. All of those things can really give a person, frankly, less control over their response to that traumatic event, and especially in the immediate aftermath, their body is just very much coming back to normal in order for them to, sort of recover from what has happened to them. It is not unusual when somebody has experienced something particularly frightening or life-threatening, as in the cases of domestic or sexual violence, for them to not be able to remember in chronological order what happened to them. And so as you're meeting with a victim, if they're coming to you for help, maybe to file for a protection order or something like that, you might find that their story doesn't come out in a very chronological or organized sort of fashion, and that's very normal. And just to keep that in mind, it's not uncommon for someone to remember something on Tuesday and then remember even more on Thursday. So you might see an evolution of information that comes from that victim. Also, because of trauma and because of that inability sometimes to remember all of the facts, a lot of times victims do delay reporting. And again, that is not something that should be taken as an indication that the domestic or sexual violence didn't occur, but rather something that's a very normal response in the wake of such a life-changing event. So some of the, those are some of the really short-term consequences of trauma, and certainly we could spend hours and hours just talking about those. But also I want to touch on the long-term impacts of traumatic events, including sexual and domestic violence. There's obviously the emotional impacts. A lot of times victims will experience, extreme emotions in the long-term impact, so they might be experiencing a lot of anger, insecurity, sadness, guilt, shame, embarrassment. We know that they're increased risk for, mental health disorders such as anxiety, depression, post-traumatic stress disorder. There can be physical impacts, which could, be self-neglect or sudden weight loss or weight gain, disturbances in their sleep, chronic health problems, which can, be things even, like hearing loss and that kind of thing. Back pain, we see it with a lot of victims. There are also direct physical impacts, obviously, especially in the case of domestic violence, where you might have lacerations or bruises, injuries that are very immediate that need to be attended to. You have to be concerned about things such as sexually transmitted diseases, pregnancies or miscarriages as a result of the abuse. And then there are also some things that we don't as commonly think of as impacts of this type of violence. And that could be things like the economic impact of the abuse. You know, if a person has to miss work or take time off of work, there could be lost wages, which puts them, you know, in a more precarious situation possibly. There are mental injuries that could impact their ability to seek employment if they need to be finding a job if they're leaving a violent relationship, for example. Medical bills that are incurred that a person might not have insurance to cover. We also see in the case of like campus violence, where there are students that might need to drop out of school and suffer financially as a result of, you know, losing that tuition money and that kind of thing. So it's also important as we talk about the impacts of these crimes to also understand a little bit about the mindset of the batterer in these situations, because that's always who we want to be focusing on and making sure that we are turning our attention to as far as looking at why these situations occur, why these things happen, because they are always the fault of the abuser or the batterer and not the victim, and we always want to remind ourselves of that. So a batterer is a person who engages in a pattern of coercive behavior to gain power and control over another person. And as Rachel had mentioned earlier, rarely are these isolated incidents. So we're really talking about, you know, a pattern of behavior where we're seeing, you know, sort of a building up to maybe a major event, and that could be in the course of hours, days, months, years. And it's rarely an isolated incident. There's most commonly a combination of factors that would include the emotional abuse, the physical abuse, and other things as well. So again, it's really that combination of behaviors over a period of time, and as you're working with victims, sort of understanding that compounded trauma that they may have suffered because of these being, you know, very rarely isolated events. And again, it's all about that power and control over another human being.
So how does the victim end the violence? Well, this is always the really tough question to answer. There are obviously different legal options for ending domestic violence and sexual assault. The first one, or one of the options, is the criminal option, which obviously involves a victim contacting the police, criminal charges being filed, and then the case being pursued through the court system to see whether or not it ends in a criminal conviction. Many of you may work with victims involved with the criminal justice system. But there is another option, and that option is the civil legal option. And that's what Karen and I are here to talk to you about today. And again, many of the victims that you work with may have civil protection orders, may want civil protection orders, and certainly need to know about them as an option. Because for some individuals, pursuing a criminal case is just not how they want to proceed. Going through the criminal process is difficult, it is long, and it is uncertain, because in order to get a criminal conviction, you need to prove beyond a reasonable doubt that the defendant engaged in that behavior. That is the highest legal standard that we have, and you essentially have to prove something 99.999%. And it is difficult to get criminal convictions, particularly in domestic violence and sexual assault cases, because oftentimes there's not a lot of independent physical evidence, and it can be very he said, she said. And so for that and many other reasons, a victim might say, I don't need them to go to jail, I just want it to stop, and I want them to stay away from me. And as you'll see, pursuing and obtaining a civil protection order is a really good option for those individuals.
And I think it's also important to point out that while a person can, choose to go the criminal route or the civil route, it is also possible to do both at the same time. So a person could seek a civil protection order and also report to law enforcement. So that's sort of a third option as well.
So what are the civil protection options? Well, it used to be that there was only one option in Pennsylvania, and that was the protection from abuse orders, or PFAs. And that was the way it's been since the 70s until July 1st of 2015, when a new law went into effect. And it is called the Protection of Victims of Sexual Violence or Intimidation Act, which provides protection orders to a different category of individuals, different from individuals that can obtain PFAs. And as we go through this training, we're going to explain that all to you and differentiate it so you know the difference. But it's really important to know that there are now 2 protection order options available. It's also important to note, as I said, this is civil. This is not a criminal process. What that means is that to obtain a civil protection order, you need to prove that you require that order, and the burden of proof is preponderance of the evidence. Remember how I said beyond a reasonable doubt means you have to prove something 99.999%. To make your case civilly, you have to prove it by a preponderance of evidence, which means 51%, just a little bit more than half. So as you can see, it's a much lower burden of proof, and it might be easier for a victim to obtain that protection order because, again, the burden of proof is lesser. It's also important to note that protection orders are given what is called full faith and credit under the law, which means that if you have a victim from New Jersey who moves to Pennsylvania and they have a protection order from New Jersey, that protection order under the law has to be honored and followed in Pennsylvania. In the same way, if you've got a victim from Pennsylvania that has a protection order from Pennsylvania and they move to Montana, that protection order goes with them and it is enforceable in the state in which they live. So before we get into the nitty-gritty about what each law offers and says, I just want to take a moment to just review the general process. Because again, a lot of individuals you may work with are going to want to know, well, how do I get one and what happens and what's it like, what's the process? So the process is identical for both PFAs and protection orders under the PSVI Act. Number one, there is no cost at all for plaintiffs to file for these orders, at all. There's no cost for them throughout the entire process. So what happens is an individual decides they want to file. They need to file the protection order with the Prothonotari's office. They may also go to either a domestic violence, a sexual assault, or a victim witness office that provides assistance. They file it that same day. They have what's called an ex parte hearing with a judge, which means the judge reviews their petition, may ask them some questions, may want to verify something, and then based on the petition and that hearing, the judge decides whether or not to enter a temporary protection order. Regardless of whether a temporary order is entered, the plaintiff is still entitled to a final hearing on their petition. And so that hearing under the law is required to be scheduled within 10 business days of the day they file the petition. So as you can see, it's a fairly quick process and certainly much quicker than the criminal process. So again, if they're granted a temporary protection order, which may require the defendant to stay away from them, that remains in full force and effect while that order is valid. And all the forms and orders are available on the Protection from Abuse database system. So what types of orders can you get? Well, there are 3 types of orders you can get under either law. The first type of order is an emergency order. So we all know that the Court of Common Pleas is not available weeknights and on weekends and holidays. Obviously, the courthouse is closed. But again, life happens, and it's not necessarily according to a certain business schedule. So if you have a victim that's assaulted on Christmas Day and they feel they need a protection order, they can obtain one. What they need to do is contact the police or contact their local domestic violence or sexual assault center who knows how to get in contact with the magisterial district judge. The MDJ is on call to handle, emergencies and things that come up when the courthouse is closed. They will have that ex parte hearing with that victim and decide whether or not to enter an emergency order. It's important to note the emergency order remains in effect until the end of the next business day the court is open. So if it's a Saturday night, that emergency protection order expires the end of Monday. And then at that point, the victim has to start the process again to go through the process and obtain a temporary and maybe obtain a final. The second type of order is the temporary order, which we just talked about. And the last type of order is obviously the final protection order. You can get that 2 ways. So you can obviously, the plaintiff can have a hearing in front of a judge where they testify, the defendant testifies, there might be witnesses, exhibits, and the judge decides whether or not abuse occurs and decides whether or not to enter an order. However, oftentimes with protection orders, the parties reach an agreement to put a final order into effect. What that agreement means is the defendant is essentially saying, if you want a PFA, I'll agree to it, but I'm not saying that I did what you said I did. So the benefit to the defendant is he enters into the PFA without admitting to any of the allegations. The judge hasn't looked at it, hasn't made a finding. The benefit to the victim is they get their order and they don't have to go through a court hearing. So again, a lot of these cases can be resolved by agreement, but obviously not all of them. And when they can't be resolved by an agreement, that is when you have a hearing in front of the judge and they'd make a decision. Okay, so now that we're kind of done with some of the process stuff, so, you know, we're talking to you about protection orders, and now that we have two types, when you talk about protection orders, really what you're talking about are relationships, because protection orders are all about relationships. They depend on whether or not you have a relationship, and if you don't have a relationship, you might be eligible for another type of order. So when you're thinking about protection orders, you always want to go to, is there a relationship, and what is that relationship? So the first type of protection order we're going to talk about, which some of you may be familiar with, are protection from abuse or PFA orders. It's important to note, though, as we all know, the criminal justice system is all about punishment. You're punishing bad acts. You did something bad, bad. You're penalized for it. You're sent to jail. You're put on probation. That's not what the protection orders are about. They recognize that a bad act happened, and they want to prevent it from happening in the future, which is why they enter stay-away orders to hopefully prevent the abuse occurring again. So for PFAs only apply to people who are either family or household members. They define that as spouses or people who live as spouses, people living as spouses, lived as spouses, parents and children, other persons related by consanguinity, which is blood, or affinity, which is marriage, current or former sexual or intimate partners, or people who share biological parenthood. Now, that's a whole lot of people, but obviously it doesn't cover everyone, which is why the Protection for Victims of Sexual Violence or Intimidation Act went into effect, which we'll talk about in a little bit. So that's who the PFA Act covers. Obviously, it covers individuals who are in domestic violence or intimate partner violence situations. It's also important to note that it absolutely applies to same-sex relationships, so it applies to everyone. It's also important to note that what case law tells us is that an intimate relationship doesn't have to be very long-term in order for someone to be able to obtain a PFA. So again, case law has told us that if you go out on a date with someone maybe twice, that's enough to qualify for a PFA. So what does the PFA Act cover? Well, it covers abuse. And the way it is defined under the Act, it is defined as bodily injury, which I think we all understand, or threat of bodily injury. Now, this is really important to remember because, as I talked about earlier, abuse is all about control. It is the control that the batterer is exerting over their victim. And so some batterers don't ever have to lay a finger on their victim because they have controlled them to the point that all they have to do is threaten, and it's enough to stop the actual physical abuse from occurring. So the PFA Act covers threats because, again, the PFA Act wants to stop abuse from happening. The PFA Act covers rape, but it has to occur within an intimate relationship, covers involuntary sexual intercourse, sexual assault and indecent assault, false imprisonment. Now, false imprisonment isn't necessarily someone locking you in a bedroom and throwing away the key. False imprisonment can be someone pushes you up against the wall and physically restrains you and holds you there maybe 10, 15 minutes. That's also false imprisonment. It also covers stalking, which, as I said earlier, is when a defendant engages in a repeated course of conduct that puts an individual in fear for their safety. The PFA Act also applies to physically or sexually abusing children, so long as children have the appropriate relationship with the defendant. We'll talk a little bit more about that as we go along, but again, many of your victims may be children, as well as the parents that are bringing the children in for services. So you're going to see a lot of that. So protections available. So the biggest protection is that the PFA states that the defendant shall not abuse, stalk, harass, or threaten the plaintiff, because really that's what the plaintiff wants. They want this behavior to stop. PFAs also often state that there can be no contact between the plaintiff and the defendant. And when I say no contact, I mean no contact. No texting, no Snapchat, no Facebook, no calling your best friend to call the other person to relay a message. No contact means no contact. Now, particularly in situations where the parties share a child, not being able to have contact is impossible. So you will see PFAs that say no contact except for limited peaceful contact regarding the party's child. So you will see no contact orders that have exceptions carved out. There are also PFAs that can be contact orders. What that means is the defendant is not allowed to abuse the plaintiff, but they can have contact. And again, that's an option. And victims know their abuser best. They know how best to handle the situation. And for them, having a contact PFA might make the most sense. There are also numerous additional reliefs in the PFA, such as a custody provision, child support. You can request that you be reimbursed for lost wages if the lost wages happened as a result of the abuse. Another big relief under the PFA Act is that a defendant's weapons may be confiscated, which means that they have to turn them over to the sheriff, and they may not be allowed to possess, transfer, or acquire firearms for the duration of the PFA. And in domestic violence situations, the presence of a weapon increases the risk of lethality for that victim tenfold. So that's a very important form of relief and protection for a victim. And these orders can remain in effect for up to 3 years.
So, Rachel, we have a question in the Q&A box. David's asking, to what extent are PFAs preventative, and what must have already occurred for a PFA to be granted? So I know we get this question a lot about protection orders because, and I'm sure you've often heard it said that, oh, it's just a piece of paper. And the fact of the matter is, it is a piece of paper, but what research has shown is that they really are effective in preventing future violence. PFAs are an opportunity to obviously separate people, to, have sort of a cooling off period in many cases. That is enough to sort of mitigate future violence. We also know that, there are real consequences to violating PFAs, which we'll get to here shortly, and that's often a very good deterrent for somebody who doesn't want to land themselves in jail. So they are preventative in that way. Now, very often, we'll see, unfortunately, on the news situations where somebody had a PFA, and even so, they were either harmed significantly or even killed in very extreme cases. And so we do hear about that. But in the state of Pennsylvania, I think there's an average of about 40,000 to 45,000 PFAs that are granted every year. And the number of, significant or extreme violations that we might hear about on the news obviously are much smaller than that. So we do know that they are effective in many cases. We also know that there are situations where, a protection order just is not going to prevent that violence, unfortunately. And so then in terms of what must have already occurred, back on the previous slide, Rachel sort of outlined what those different behaviors are. So it could be that bodily injury, but also that threat of bodily injury. It could encompass other behaviors as well that are, include sexual violence and some of that verbal and emotional abuse that we've talked about as well.
It's also important to note that for a victim to obtain a PFA, the act of abuse as defined under the law had to occur relatively recently. Now, I can't tell you it had to occur within 48 hours because the law doesn't say that. But what case law has borne out and what courts like to see is that it happened this week, this last week, maybe a month max. They want it to have happened relatively recently because not only do you have to show that abuse occurred, you have to show that you're afraid. And so the thought is, well, if it happened 6 months ago and you didn't do anything about it, I'm not so sure you're afraid, which may or may not be true based on a lot of factors, but that's what the courts want to see. The courts also, though, if a recent incident of abuse occurred, but there was a pattern of abuse in the past, which is very common in domestic violence cases, the court will also consider past abuse when they make their decision. But again, the actual incident of abuse that leads the individual to file for that protection had to happen relatively recently, but there's no set time period on that.
And then Valerie was asking if we can explain if a victim can seek compensation for lost wages.
Yes, they can. So you can, or a victim has the ability to seek compensation for lost wages in a variety of ways. If they missed work because, let's say, they were hospitalized or they were too injured to work, they can request through the PFA relief that they be reimbursed for lost wages that are directly related to the abuse. So you can do that in the PFA and try to get a court to order that the defendant has to pay X amount of money. Victims can also request lost wages related to the abuse if they file a claim with the Victims Compensation Assistance Program, otherwise known as VCAP. You can't double dip. You either get it under the PFA or you get it through VCAP. But sometimes, because defendants are not the best at paying when they're ordered to pay, obtaining that reimbursement through VCAP might be a more certain way of obtaining that compensation. The third alternative to get reimbursed is if there's a criminal trial, they're found guilty, and you can request it through restitution. But again, that's going to take much longer than getting it through VCAP or getting it through a PFA. But a victim does have options. Now, if that occurs, what the victim has to do is they have to be able to prove that they missed work because of what happened, which usually requires medical documentation, maybe a slip from the ER, a note from a doctor, and then they will have to submit actual documentation from their employer about you missed 8 hours of work and that equals $200. You know, you can't just make up an amount of money that you would have gotten paid. So they have to submit paperwork, whether they're getting that reimbursement through a PFA, through VCAP, or through a criminal proceeding.
And then Valerie was following up to ask about missing work for the actual time spent filing for the PFA, whether they could request compensation for that.
They can certainly request it. That's not necessarily guaranteed that they'll get it. They can certainly request it, and they might have more success with that through the Victims Compensation Assistance Plan than they would a PFA. But my attitude is always ask for it, because the worst thing that can happen is they say no, but at least you tried. So I say go for it.
All right, thank you, Rachel. So Rachel just gave us a great overview about the PFA Act, and so now we're going to shift gears a little bit and talk about the Protection for Victims of Sexual Violence or Intimidation Act. As Rachel had mentioned previously, this law went into effect July 1st of 2015. And the major difference, again, between the PFA Act and what we commonly call the PSVI Act it really boils down to the relationships of the parties that are involved. And just to give you a little history on this act, you know, as Rachel mentioned, the PFA Act covers people that have intimate partner and family member type relationships. And what those of us who worked in the field of sexual violence were finding were that victims were coming to us and perhaps they had been sexually assaulted by, you know, a friend or a coworker or, you know, a stranger, and they would say, you know, I'm not sure I want to report to the police, but I want this person to stay away from me. Can you help me file a PFA? And unfortunately, they didn't have those appropriate relationships that were covered by the PFA Act. And so over 10 years ago, Senator Greenleaf had introduced legislation for the Sexual Violence Victim Protection Act that would afford those protection order type options to victims of sexual violence that weren't covered by the PFA Act. As I mentioned earlier, the act that was ultimately passed included the piece about intimidation. That was added much later as an amendment, and I'll talk about that shortly. So right now, we're just going to focus in on those victims of sexual violence and the protections that are afforded to them under the PSVI Act. So we did talk a bit earlier about the impacts of domestic violence and sexual violence and the impact of trauma on victims. And I think, you know, as we're all aware, these crimes are unfortunately much too common. And we know that 1 in 3 girls and 1 in 6 boys will likely experience sexual violence by the age of 18. Numbers for college students, this has been in the news an awful lot lately, that 1 in 4 or 1 in 5 young women will be assaulted by the time they leave college. For young men of the same age, we're looking at numbers of 1 in 16 men. And then students that identify as LGBTQ have even higher rates of victimization. So this is a significant issue. You know, lifetime prevalence for women is upwards of 63% and 24% for men. So there are a lot of victims of sexual violence that were also really needing protection and feeling as though they were falling through the cracks because their types of abuse or the people that abused them weren't covered under that PFA Act. And we know, again, like Rachel had mentioned, that these are the numbers that are reported to us. So the scope of the issue is likely much larger. And we also know that, especially with sexual violence, delayed reporting is much more common than it is for somebody to come forward right away. So again, that should never be viewed as an indication of whether or not the abuse occurred, or it should not be used as a measure of how serious the event was to that person, because we know because of the impacts of trauma and many other things, victims of sexual violence often hesitate to come forward right away for many reasons that, you know, that make sense to them as individuals and also to us as victim advocates who work with them and know how absolutely devastating these crimes can be on people. So when we talk about sexual violence, there's often a lot of controversy. You know, I mentioned those statistics about prevalence, and there's often some controversy about, well, is it really 1 in 4, or is it 1 in 5, or, you know, what are the numbers really? You can read different research studies that have different prevalence rates in them. I mean, my argument is always that the numbers are too high and that we don't really need to quibble about it. But part of the problem is that sexual violence is defined different ways depending on what you're looking at. So one research study might define it in one particular way, whereas another research study might include entirely different types of behaviors under their definition of sexual violence. We know that from state to state, the definitions can vary. So what is a crime in one state may not be in another, or how they're categorized might vary from state to state. So it can be kind of confusing. But for the purposes of the Protection for Victims of Sexual Violence Act, and for the people that are eligible for a sexual violence protection order, this law defines sexual violence as any conduct that is a crime under Title 18 of the Crimes Code. So even though this is a civil act and not a criminal act, it's completely separate, they use the criminal definitions. So in Pennsylvania, sexual violence under Title 18 includes all kinds of sexual offenses, so the things you would commonly think of, such as rape, indecent assault, aggravated indecent assault, involuntary deviant sexual intercourse, statutory sexual assault. Those kinds of crimes are all covered by this act. Additionally, there are crimes such as endangering the welfare of children if that contact is sexual. So you have to have that sexual violence component to the endangering welfare of children crime. Corruption of minors, same thing. The contact or the allegations have to involve sexual abuse of some type. Sexual abuse of children and sexual exploitation of children. And as Rachel mentioned, you know, some of these crimes are also covered by the PFA Act, but you need to really look at that relationship between the parties involved. Because the PFA Act covers those family members, intimate partners, whereas this act covers everybody else. So you want to think about relationships such as neighbor, friend, coworker, classmate, stranger, acquaintance. Those types of relationships are covered under this act. So in addition to get one of these orders, a victim must allege that they are the victim of one of these crimes, and also they need to demonstrate that they are at continued risk of harm from the defendant. And when you think about what Rachel said about these orders being meant to be preventative, that's why this piece is important, because they want you to demonstrate that continued risk of harm, because the order is meant to prevent that future harm. So there has to be the risk of harm from the defendant. Now, what does that really mean? We're not really sure. The Act doesn't officially define what continued risk of harm means, and what we've seen from across the state is that different courts are sort of understanding this in different kinds of ways. So what you see in your community might be different from what's happening in other areas of the state. So in some courts, we're seeing that continued risk of harm might include additional behaviors. So maybe there's somebody that's driving past the victim's bus stop all the time, or sending notes or text messages, or sort of retaliating against that victim, threatening them not to report. Those types of behaviors could certainly constitute continued risk of harm. What we're also seeing is some courts are interpreting that to include such things as those long-term effects that we talked about previously. So if a person is at continued risk for post-traumatic stress disorder, we know that they're, more likely to suffer challenges at work or at school, that those could also be considered continued risk of harm. And as Rachel mentioned earlier, it's going to vary from county to county and judge to judge, and that, there's never any harm in seeking the best protections you can for the victims that you're working with, and ultimately it's up to a judge to decide whether you've met that bar or not. So now we're going to shift gears a little bit, and we're going to work on some scenarios together, because as you all know, what seems really clear on paper is often not so clear when you involve actual human beings. So this is going to be the time where we're going to ask you to use your chat boxes. We're going to read through a scenario and give you some options, and then ask you to respond through the chat. So in this situation, we have Lucy. She was raped by a coworker who threatened to hurt her if she ever told anyone. And although they don't have much contact during the workday, her perpetrator now leaves work at the exact same time that she does every day and follows her to her car. And he never did this prior to the assault. He never says anything directly to her when they are in the parking lot, but she feels afraid and intimidated him because of the fact that he had previously raped her. So for this situation, do you think would Lucy be eligible for a PFA, a sexual violence protection order, or none of the above? And again, we want you to go up and use that chat box in order to answer.
Okay, we'll give you a couple seconds to put your chat in. Give you guys a couple more seconds to cast your vote. Let's see.
All right, looks like some folks are maybe having trouble with the chat box.
So if you're having trouble with the chat box, you can certainly put your response in the Q&A section. Okay, we're going to close polling in about 10 seconds. Okay, great. Polling is closed. So what do we have here?
All right, so it looks like we have a variety of answers. So let's just talk through them together. So the first option would be the PFA. And so again, what we want to look at is what is the relationship between Lucy and the perpetrator and her coworker. And again, they're coworkers. So that is not a relationship that's covered under the PFA Act. So since we feel that that might not be an option for Lucy, we want to look at the Protection for Victims of Sexual Violence and Intimidation Act and see if a sexual violence protection order might be an option for her. So again, we have the allegation of the rape that she has reported, and that continued risk of harm. You know, she has that fear because he's following her to her car and that kind of thing. So it seems like that would absolutely be appropriate in this situation. And again, this might be a choice that Lucy would make. It may not be a choice that Lucy would make. You know, again, she could file the order and then the judge could decide whether it fits the bill or not. But certainly a sexual violence protection order seems like it could be a good option for Lucy. So we have a question here that if the case goes to a judge to make a decision because an agreement cannot be made, does the judge first have to make a finding that a Title 18 offense has been committed first? And if so, is that beyond a reasonable doubt? And the answer is that the judge does have to find that the abuse occurred, but again, it's just using that preponderance of the evidence, so it would be 51%. This does not have the same burden of proof as the criminal charge would.
Now, admittedly, the way the law is written, it can be a little confusing. Well, if it's civil, why are they referencing a criminal statute which has a higher burden of proof? Obviously, we didn't write the law, so we can't speak to why they wrote it this way, but this is very clearly a civil case. Interestingly enough, this issue was raised on appeal in Butler County by a defendant's attorney who said, you know, no, a criminal, if you want it to be criminal, a criminal act had to happen and had to be proved beyond a reasonable doubt for this to apply. We don't think that's the case, and we're fairly confident that the appeals court will agree with us. But again, because this is such a brand new law, we honestly have to wait and see what develops with case law. But as it stands right now, the judge absolutely does not have to find that an abusive act occurred beyond a reasonable doubt because this is a civil proceeding. But it's an interesting question.
And hopefully we've answered your question to the best that we can at this point without further case law. But our understanding is that really they just use those Title 18 definitions as a way to have common language between the different laws so that we all understood what we're talking about when we talk about sexual violence. All right, so let me get back up here to change our screen. All right, so our next scenario, we have Jennifer, and she was sexually assaulted by her neighbor who lived next door to her and who she used to date. After the assault, she moved out of her apartment building and filed a police report. The perpetrator found her new address and has been contacting and harassing her to try to convince her not to press charges. So in this situation, would Jennifer want to file for the PFA, the sexual violence protection order, or none of the above? What do we think?
So again, we're going to do it like last time. So if you can put your response in chat or Q&A, whatever works, that's great. We will give you guys a minute. So put your responses in. Okay, we'll give you guys about 30 more seconds, so go ahead and vote away. All right, and we're out of time, so cast your vote, and we will close the poll.
All right, so let's go through and talk through these situations. So we're talking about Jennifer. She was sexually assaulted by a neighbor, but they used to date. So again, as Rachel had mentioned, that dating relationship does not have to be terribly significant in order for Jennifer to qualify for the PFA. So in this situation, it would make most sense if Jennifer wanted to file for a civil protection order to file for that PFA because of that previous dating relationship. Had they never dated before, then you would want to look at that sexual violence protection order. But because of that past dating relationship, the PFA would be most appropriate. Now, we've gotten a lot of questions about how long ago was that dating relationship and does it still count? So, for example, if Jennifer is now 50 years old and she previously dated this person when they were in high school, does that still count? And if you follow the letter of the law, in theory, yes, it would still count, but we also know that some judges across the state have varying opinions on that and feel as though if the relationship was that long ago, it may not have relevance on what's happening currently. But according to the law, that prior dating relationship, no matter how long ago it was, would still have relevance.
Now, we do have a question that someone's asking to clarify. They do not have to be under the same roof. Absolutely, they do not have to live together. Obviously, a lot of people date and they don't move in together, and that's an intimate relationship which would qualify for the PFA. So they absolutely do not need to be living together or have lived together. Absolutely not. It's also important to remember that you're not eligible for a PFA and a PSVI. You're just not, because you either have the relationship or you don't. So you get one or the other. And hopefully remembering that will help you analyze the situation and, you know, have a stronger sense of which order is appropriate, because it's all based on that relationship.
And the one other issue that we've seen pop up across the state sort of related to this about the being under the same roof issue is we do know that there are plenty of people that maybe live in the same house, rent rooms in the same house, but aren't necessarily in any kind of intimate partner or family member relationship. So I think about college students where there might be 5 or 6 of them living as roommates in the same house. And what we've heard across the state, again, is that there's sort of some what do I want to say, different ways of viewing this, where some judges have said, well, if you're all at the same address, that counts as a PFA. But other judges who would say, no, just because you happen to live at the same address doesn't mean you have that family member, intimate partner relationship. So there may be some variation within communities about how this is being interpreted. And so that's why it's always a really great idea to go and talk to those folks that do a lot of work with protection orders in your different counties and talk to them sort of about what they see and how the processes work and the types of decisions that their courts are making in that particular county.
Yeah, and a really helpful thing to do if you aren't familiar with the protection order process, if you've never sat in PFA court, you really may want to, because PFA or protection order court happens with absolute regularity in most counties, so you know when it's scheduled, it's open to the public, so it would probably be a really good idea to just go and sit for a little bit and just get a sense of what it's like, because it will help inform the work you do. It will also put you in a better position to be able to explain to a victim what it's like if you've actually seen it yourself.
So as I mentioned earlier, under the Protection for Victims of Sexual Violence and Intimidation Act, we actually have 2 different types of orders. So we have the sexual violence protection orders, which we just talked about, and then we have the new protection from intimidation orders, which, as I mentioned, were added as an amendment much more recently in the whole process. And these orders, or this amendment, actually came about as a result of a very specific incident and situation that happened out in the western part of Pennsylvania. There was a young girl who worked as a soccer referee, and there was a coach that was, acting negatively towards her and harassing her a lot and saying things to her that were making her feel afraid and uncomfortable. And he would act that way whether she was reffing his games or just if he saw her at this, soccer complex or whatever. And so clearly her family wanted to make this stop, and her parents went to find out like what they could do about it, how they could protect their daughter. And, because this was a player or a referee coach kind of relationship, this was not a family member, intimate partner type relationship, they were told that there was no protection order option for them. And for whatever reason, they opted not to go the criminal route. And clearly this young girl was very disappointed because she ended up having to quit her job as a referee because she didn't want to have contact with this adult man who was harassing her. And she ended up partnering with an organization out in the Pittsburgh area that helps girls to become active in political advocacy. And they really championed her cause and helped to draft some legislation that would extend civil protection order options in very specific situations where an adult is harassing or stalking a child. And so we'll talk about that more fully here in just a second. So in the state of Pennsylvania, there is no crime of intimidation, but again, this law uses Title 18 to define it. So within this law, intimidation is defined as harassment or stalking. And again, to know what that is exactly in Pennsylvania, you can go back to Title 18 to the Crimes Code and read what those behaviors are. So for harassment, under the law, a person commits the crime of harassment when, with the intent to harass, annoy, or alarm another person, that person communicates to or about such things in lewd, lascivious, threatening, or obscene words. They can use language, drawings, or caricatures. They can communicate repeatedly in an anonymous manner or communicate repeatedly at extremely inconvenient hours, or communicate in manners other than specified above. So that could include, texting, that can include face-to-face, that can include over the phone, letters, if people still do that anymore. It can include all types of behaviors. And it's important to note that the intimidation does not have to be sexual in nature. Now, it's lumped in this law along with the sexual violence protection orders, but the harassment or stalking does not have to have sexual components at all. Now, certainly we know that it's likely that they might, but it doesn't have to. It could be, completely non-sexual type harassing or stalking behaviors. So harassment really encompasses a lot of things, because there's an awful lot a person can do to harass, annoy, or alarm another person. And then we also have stalking, which is a little more specific because it requires a continued course of conduct. So that behavior has to happen more than once. It has to happen repeatedly and with the intent to cause that other person fear of safety or fear from harm or, bodily injury, that kind of thing.
So we have a question. Someone's asking, what about a student who was physically or sexually assaulted and is harassed in school?
Well, and that's sort of an interesting question because the other part of the intimidation orders are that the perpetrator must be 18 or older and the victim must be under the age of 18. So if you think back to that original scenario of the coach and the young soccer referee, we're really talking about situations where adults are harassing children. Now, again, we know that within a school setting, it's likely you could have a 17-year-old and an 18-year-old student, or you could have an 18-year-old student and a 14-year-old student. So absolutely, these could be applied to situations within schools. However, they have to meet those specific age requirements. So you could not get an intimidation order in cases where you'd have two 13-year-olds, for example, that are harassing each other. Age is not a factor at all for a PFA or a sexual violence protection order, but for the protection from intimidation order, the perpetrator must be 18 or older and the victim must be under the age of 18.
It's also important to remember that in the scenario you mentioned where a student was physically or sexually assaulted and then harassed in school, it depends on who's doing the harassing. If the perpetrator was the one that actually physically assaulted them and the ages work out, they may be able to get this type of order. But if it's other students who didn't assault that person but are harassing the student, you could not get a protection order against those individuals because they didn't perpetrate the underlying crime. You can certainly pursue criminal charges against them. That is always an option. But in terms of a protection order eligibility, we don't have a law that fits that.
The other important thing to note about things that are happening in schools, because a lot of people are concerned that these protection from intimidation orders do not apply to child-on-child or minor-on-minor types of harassment or stalking, is that most schools, if they receive federal funding, do have to comply with Title IX, which prohibits sexual harassment and sexual violence in schools. So if that type of gender-based violence is happening, even between younger students, schools will have protections that they can put in place outside of the civil protection order option to protect those kids.
We have another question that asks, does Pennsylvania have any type of protection orders for adults who are outside of a domestic violence or sexual assault relationship? The answer to that is no. There are no civil protection options for adults who don't qualify as victims of domestic violence or sexual assault. However, if let's say there are criminal charges because that adult was robbed by another adult, as part of the criminal charge and bail conditions, the district attorney can put in place a protection order related to that charge. But that's obviously not the same as having an independent civil protection option. In some states, protection options are available to everyone under any circumstance for lots of different reasons, but Pennsylvania doesn't have that at this point.
So under the Protection for Victims of Sexual Violence and Intimidation Act, the protections afforded are slightly different than what is afforded by the PFA Act. So what we see within this act is that a victim can request that the perpetrator not be able to contact them. That is pretty standard and usually the reason why people are asking for these protection orders. And then also there's sort of this kitchen sink idea of any other appropriate relief. So where the PFA really spells out specific things that can be asked for, this order is really, or these orders are really pretty broad and wide open. So under that other appropriate relief, a person might still want to seek restitution for medical expenses, lost wages, counseling expenses. They might want to put into place other kinds of things. We've heard about some folks using these protection orders for eviction purposes, whether the perpetrator might be living, in the same apartment complex or a landlord-tenant type relationship. And although this act does not specifically mention weapons at all, certainly if a weapon were used in the commission of a sexual assault or threatened to be used, I would think a victim might want to ask for that to be relinquished as well. So really, this is an opportunity for victim advocates to really talk with victims and help them to tailor these orders to best meet their individual needs. And then lastly, the final orders, like the PFAs, can be in effect for up to 3 years or whatever the judge prescribes. And we've received questions particularly relating to the protection from intimidation orders because they are granted only in cases where minors are victims. People have asked, well, if a kid gets a protection from intimidation order when they're 17 years old, does it expire when they turn 18, or does it actually stay in effect for those 3 years until that person would turn 20? And again, we don't have case law yet to give us a clear answer on this, but our assumption is that if a judge were to order a 3-year order to protect a 17-year-old, that the judge would intend for that order to stay in effect for those 3 years, that the order would not expire upon the 18th birthday of that victim.
So for both the PFA Act and the PSVI Act, both of those acts have written into them a lot of legal protections for victims, which is important for you to know when you're working with those victims. One of the biggest protections available under those acts is the act provide for absolute confidentiality when a victim of domestic violence or sexual assault is speaking to a domestic violence or sexual assault advocate. And what that means is that advocate has to be employed by either a domestic violence or sexual assault agency and undergo rigorous training to qualify as an advocate. So that confidentiality allows a victim to tell their counselor or advocate anything, and that advocate cannot disclose it, cannot be required to testify in court about it, cannot say a word to anyone unless that victim specifically authorizes them to do that. Now, the only exception to that confidentiality is obviously in the case of the victim maybe making allegations about child abuse or saying something to the advocate that leads them to believe child abuse is occurring. They can or they are required to make a mandated report of child abuse, but otherwise their conversations are confidential, which can be so critical to victims who don't want to talk to anyone, who are embarrassed and ashamed and are really worried that if they tell someone what's been happening, their perpetrator might find out. The laws also provide for address confidentiality, which is particularly critical to victims of domestic violence who oftentimes have to flee the abuser and don't want the abuser to learn where they're living because they're afraid if the abuser finds out, they will come and get them. So they don't have to require their address to be listed in the petition. The acts also require that if if a victim wants an advocate to come with them to court to help them. Obviously, an advocate's not an attorney, so they're not there to legally represent them, but they are allowed to be accompanied by a legal advocate, which can provide a huge amount of support for that victim to enable them to go forward on their case. So there are a lot of protections already provided in those laws. So remember how I've been saying these acts are civil? I kind of lied. I didn't really lie, but I lied a little, because they're civil until they're violated. And when they're violated, they turn quasi-criminal, which I know can be a little confusing, so why did I say they're civil if they're not? Well, they are. However, these protection orders have teeth, which goes to why they are effective, because for either type of protection order, if a defendant violates it, let's say the defendant isn't allowed to call their ex-girlfriend, and they do, that's a violation. And they can be jailed for up to 6 months or fined up to $1,000 for that violation. So again, that's where the teeth comes in. So if someone has a protection order and they come to you and say, all you did all weekend is call me and text me, you need to let them know that that's a violation of the order if the order says they have to stay away. If the victim wants to pursue that violation, they're the ones that need to contact the police and report that violation. That violation doesn't automatically get reported. You're not required to report it. That's really in the hands of the victim. If the victim reports that violation, the law says that law enforcement shall arrest. They shall arrest the defendant, and it goes through the legal system, and the legal system figures it out. It's prosecuted by the district attorney's office because, again, as I said, it's quasi-criminal, and they either have a hearing where a judge determines whether or not there was a violation, or the defendant can agree to plead guilty, usually in exchange for a reduced sentence. So this is very important for you to know about and to be able to talk about with clients because, again, that's the teeth behind these protection orders. It's also valuable to know that sometimes there isn't an indirect criminal contempt, but there's still a violation. So if you have a protection order that says that the defendant has to reimburse the victim $200 for missing work, and the defendant doesn't, and the victim says, I need my money, I want my money, what do? Well, the victim can file what's called a civil contempt and take it back to court to enforce that provision of the court order which requires the defendant to pay that money. So again, there are lots of methods of enforcing the order and making sure that they remain in effect and that the defendant knows they're in effect.
Okay, so we're going to talk through another scenario. In this situation, we have Molly. She's 12 years old, and she lives with her mom and her mom's boyfriend, Todd. Todd has been living with them for about 4 months. Todd has always taken an interest in Molly, and for the past month, he's really sort of shown particular interest in her, and he's been accidentally touching her, and by accidentally, I'm putting that in quotes. He's touching her inappropriately and walking in on her while she's getting dressed. What we're talking about is sort of that grooming behavior that we often see prior to an abuse. And so Molly feels completely uncomfortable and has been avoiding Todd, and she told her mom that she wants Todd's behavior to stop. So in this situation, what order would be most appropriate for Molly? And I'm going to shake things up a little bit, and I'm going to add an additional option. So we're going to have option A will be the PFA. Option B would be the Sexual Violence Protection Order. Option C, we're going to throw in the Protection from Intimidation Order. And then option D would be none of the above.
Okay, we'll give you about a minute, so go ahead and decide what order you think might work in this situation. Let us know what you're thinking.
Again, A, PFA, B, sexual violence protection order, C, the protection from intimidation order, D, none of the above.
Okay, you got about 20 more seconds to cast your vote. Feel like a game show host. Okay, last second. Cast your vote. All right, the poll is closed.
Okay, so it looks like we have quite a bit of, quite a few variations on what people think, so let's talk through them. What we really want to look at in this situation is what is that relationship between Todd and Molly, right? Because he's the offender, she's the victim, and we want to sort of try to figure out what their relationship is so that we can move forward with determining which order is most appropriate. So in this situation, Todd is Molly's mom's boyfriend, and, you know, it sounds like he's been around for a while, but just moved in with them about 4 months ago. And so we need to figure out, do we think that that is a family member type relationship? And again, what we're seeing across the state is that we get different answers and that different courts might respond to this in different ways. And so the question is, you know, how you feel about them, and are they really engaged in sort of that quasi-parent-child type relationship or not?
Right, and it's important to note that PFA case law has already answered this question. There was a case where the mom had a child, not with the boyfriend, but the boyfriend moved in, and the boyfriend lived with them for years and years and years. And the boyfriend really acted as this child's father, took her to soccer, did her homework, you know, engaged in parental behaviors, and ultimately ended up sexually molesting this child. And they went to PFA court, and mom got a PFA for her child, and dad appealed it and said, I'm not a family member, I'm not her dad, I don't qualify. And the PFA court analyzed it and said, well, the PFA Act was written in a flexible way to reach out and protect as many people as possible. And yeah, you guys have lived together for a long time, and yeah, you kind of acted like her dad, and yeah, you did her homework, and yeah, gee, you and mom went on to have children together, so you gave this child a step-sibling. That's enough. That counts. Now, those facts are not present in this case because, as we said, Todd has moved in a couple months ago. He's really not acting like Molly's dad at all. So if I were a judge, I would look at this case and think, you know what, they don't have a relationship, so a sexual violence protection order would be appropriate. However, I can honestly see a judge who would say, no, this is a relationship. If they're living in the same house, that's enough. So again, I think the appropriate order is a sexual violence protection order, but a judge may say, no, this is a PFA. Either way, she's going to get some protection. Now, I know a bunch of you guys picked C, which would be a protection from intimidation order, and that is a correct option if it's decided that they don't have a relationship. Because, again, we told you in order to get a PFI, the victim has to be under 18, which Molly is, and the perpetrator has to be over 18, which Todd is. And, again, I think it's easy to make a case out that Todd's behavior is harassing. And so that probably qualifies. Does it really make a difference which one you file for? Not really. It's the same relief. So either way, it doesn't matter. But what's also important for you to note is that Molly's a minor, which means she's under 18. And that means Molly can't file. She doesn't have the legal standing to do it. She can't walk into the courthouse and say, hey, I want an order. She needs an adult, a household member, or a guardian ad litem appointed to represent her. And that adult is the one who actually has to file for the order on her behalf. Molly doesn't make that decision. She's not able to file on her own. So again, it's important to remember that if you're dealing with a minor victim, they will, a lot of the time, be accompanied by an adult, and if they're thinking of filing for something, the adult has to be with them to file on their behalf. And again, especially when kids get a little older, into those nasty tween years, which I'm about to experience with my son, a lot of times kids aren't going to agree with their parents. So I often saw cases where the parents did not agree with the older boyfriend and wanted to put a stop to the relationship, and so filed a PFA on the child's behalf. But the child was saying, no, it's my boyfriend, I love him, you know, I don't want this. Well, the child doesn't get to decide if they're going to file. That's the adult's decision. But ultimately, it ends up being a decision for the court to decide if it's warranted or not. So you might come across some unhappy, uncooperative kids in these types of situations. So I think we had a question from earlier that asked, how does one file the civil contempt for non-payment? That depends on your county. We have 67 counties, and we have 67 different ways of doing things. So there are different options for filing. People that have protection orders are able to file on their own. They can file a pro se process. You can go to the Prothonotary office. They might have forms for you. But if it's a PFA or a PSCI, I would contact your local agency, domestic violence or sexual assault, and ask them how they do it. They might say, hey, we have the forms, or this is how we do it, or hey, we have an attorney attached to our agency that can help, or gee, you really need to go to the legal services office. So again, in the work that you're doing, connecting with, if you're not already a part of your domestic violence or sexual assault agency, will offer great assistance to you in terms of how you do your work, and also figuring out how things work, because it's impossible for us to say there's only one way of doing things, because we have way too many counties with different ideas about things.
There we go. Okay, we're going to talk about another scenario. In this situation, we have Monica. She's an 18-year-old high school senior, and she was sexually assaulted by Joe, who's a 20-year-old acquaintance she met at a party. Joe has been texting Monica threatening messages in an effort to keep her from telling her parents about what happened. He's even been sending threatening texts to Monica's younger sister. So Monica's 18, Joe is 20, and the sister is under 18. So in this situation, which order would be most appropriate for Monica? Remember, Monica's the 18-year-old. Would it be the PFA, the Sexual Violence Protection Order, Protection from Intimidation Order, or none of the above? What do we think?
So I know you're all loving these poll questions, so I'm going to give you guys a minute to vote. Start your voting. All right, about 20 more seconds, and then we are going to close the poll. All right, one more second, and we're ending the poll.
All right, so I saw lots of B's flashing up, which would be the Sexual Violence Protection Order, and so you all get a gold star for that one. So let's talk through this a little bit. So again, Monica's 18, Joe's 20. He's an acquaintance she met at a party. So based on that relationship, just that acquaintance-type relationship, we know that a PFA would not be appropriate because they don't have a dating relationship. They're not, members of the same family. So the Sexual Violence Protection Order absolutely makes the most sense for Monica. Now we want to talk about Monica's younger sister, because Joe's sending her threatening text messages as well. Is there a protection order that would be appropriate for her? So we want to talk about Monica's sister. Remember, she's younger than 18. Do we think it would be the PFA, the Sexual Violence Protection Order, the PFI, or none of the above?
Ooh, you guys are good. You're voting already, and I didn't even have to say it. Keep your votes coming. I know it's nearing 3 o'clock. We're all getting a little sleepy.
All right, last call. Make those votes. All right. Oh, okay, a couple more sneaking in.
Okay, 10 more seconds, and then we're closing it. Put your vote now or forever hold your peace.
All right, so that time I saw lots of C's flashing up. You guys are voting for the Protection from Intimidation Order, which would absolutely be the right fit in this situation because Monica's sister is under the age of 18, and she's receiving these threatening messages from Joe, who is 20 years old. Now, there's actually a third option in this scenario, where if Monica files for the Sexual Violence Protection Order, as we discussed in our last poll question, she could also include her sister as a protected party within that Sexual Violence Protection Order. So in theory, Monica's sister would not necessarily have to file for her own protection order. So she could be covered by Monica's order. However, if for whatever reason Monica says, I don't want to deal with this, I'm not filing for an order, Monica's sister could still seek that Protection from Intimidation Order if she wanted Joe's behavior to stop. Again, Monica's sister is under the age of 18, so we know that she has no legal standing, as we talked about, and so she would need to have an adult file on her behalf. And that adult can be a parent, an adult household member, or a guardian that could file on her behalf.
Okay. So this is a scary slide because there's a big red X, and you're thinking, oh my goodness, what's unauthorized practice of law? I can't do it.
You know
hold on. We got a question.
Real quickly, before we move on, let's just answer. We got a question about the Monica scenario and whether Monica could file on behalf of her sister. In theory, she could. You know, again, she can file for her own order and list her sister as that protected party because Monica's 18. Monica, even in theory, if she did not want to file for her own order, she could still help her sister file for that Protection from Intimidation Order.
Yeah, it doesn't always have to be a parent. Let's say Monica's living at home, but she's away from college, but she's her sister and her primary residence is home. She could absolutely qualify. So that is an option. All right, back to the scary slide. So it's important for me to talk a little bit about the unauthorized practice of law because you're going to be dealing with victims and clients who are part of the legal system or they're trying to obtain legal relief, and they are going to come to you with a lot of legal questions. What should I do, and how does it work, and what do you think, and what do you think my best options are? You're going to get those questions all the time, and so you need to be prepared for it, but you also need to understand that you're not attorneys. And because you're not attorneys, you cannot give out legal advice. Legal advice interprets the law. It says, well, the law says this, and I think based on your situation, you should do this. That's legal advice that only a licensed attorney is allowed to give out. Now, what you can do is provide legal information to people. Common concepts, general, well, PFA court is held on Wednesday and it's in this courtroom, or yes, there are protection order options. One is a PFA and one's a PSVI order. Very general concepts that will apply to everyone, but that are not specifically tailored to any individual. Now, a lot of the people you're working with are going to be in crisis. They're going to have a lot of trauma that happened, and, you know, they're going to be at a point in their life that they never anticipated and they need help. And you want to help them because that's a huge part of your job. And so they'll say to you, what should I do? Or what do you think? You cannot respond to that question because, again, you're not an attorney. You can't give them specific legal advice. What you can do is provide them with general information and say to them, I think you should consult with an attorney. And so that's why it's very important for you to figure out in the county in which you're working, where's the legal services office? Does the domestic violence program or the sexual assault program have attorneys attached to it? Because many do. You want to have those resources available for that victim you're working with. You want to say, I'll take you to their office. I'm happy to walk you there and support you. But again, you can't give out actual legal advice because it's illegal. Unauthorized practice of law is when someone practices law or holds themselves out as someone entitled to practice law. Now, there's no actual definition of what practicing the law means. Don't ask me why that is, but so what that means is if someone working in a victim witness office or an advocate or a court personnel gave out legal advice, that could be construed as practicing law, and it's a crime. So not only is it potentially a misdemeanor in the 3rd degree, but it also could have really negative consequences for your employment, because your employer, I'm sure, does not want their employees giving out legal advice, giving out bad advice, giving out wrong advice. Again, you know, these individuals are coming to you looking for help, and you certainly don't want to provide them with legal advice that could really negatively impact their case. So have the attorney do that. Blame it on the attorney, and I can say that because I am an attorney. So you can blame it on the attorneys, but again, that's not your job. And you just need to keep that in mind because, again, I know it comes from a good place and you want to help people and they're in a tough position, but you have to remember that you have absolute limits to the types of advice you can give and the types of information that you can provide.
And the one thing that PCADV and PCAR have developed are different resources that outline very basically what the different types of protection orders cover, the types of relationships they cover. We have flow charts so that, you know, people can look at them and determine which order is best for their particular situation. Because again, you know, our jobs as advocates is to help people understand what their different options are and empower them to make those decisions themselves. So not only do we not want to be pretending we're lawyers, we also want to make sure that we're giving the decision-making power to the victims that we're working with. Because very often, too, we know that we might not have all of the information either. You know, perhaps if there was that past relationship that happened 10 or 15 years ago, a victim may not understand that that's still relevant to their case now. And so by explaining to them all the different options, they can choose for themselves which best fits without necessarily, you know, not necessarily based on an incomplete story that we as advocates might have initially heard. You know, providing them with that information allows them to make the complete decision that really is ultimately what we want to empower them to make.
So just to help flesh out what we've just talked about, we're going to give you one last scenario. So here it comes.
Okay, so Brian isn't, sorry, my tongue is getting tied. Brian and his mom come into your office, or maybe they come into the courthouse and you happen to be meeting with them, and Brian's mom wants to file a protection order on Brian's behalf because she says he's been getting threatening and intimidating texts and Facebook posts from another student. Brian and this other student are both sophomores in high school, so they're both 16 years old. And what could you advise them?
So, are you going to ask them to get a PFA? Tell them they can get a sexual violence protection order? Tell them they're eligible for a PFI? Or none of the above? So, cast your vote. Give you guys about 20 more seconds. So remember, this is a last poll, so make it good. Cast your vote.
Prove you're still awake.
Okay, poll is closed.
All right, so we saw lots of D's flashing up because as we now know after listening to the webinar, if we have two 16-year-olds involved in harassing type of texting or Facebook posts, you're absolutely right. No order would be appropriate in that situation. However, what we might come to find out is if these texts include sexually explicit information or pictures, or if the Facebook posts do, that could be a game changer. So again, we want to be sure to give Brian and his mom all of the information they need to make the decision that's best for them, because we may not have all of that information that they have, and they're the experts on their situation. But let's just say this is a straight harassment kind of situation, no sexual content involved. You're absolutely right. There's really not an order meant to fit that between two 16-year-olds. However, if Brian's mom is insistent and wants to file, that is absolutely their right to do so. Even if you know in your heart of hearts it'll go nowhere, that is their right to file that order regardless of whether we as victim advocates think it's appropriate or not.
Because remember, the only person that can decide whether or not an order is appropriate is a judge. That's not a decision you can make. That's not a decision an attorney can make. And again, if Brian's mom says to you, let's say you lay out all the protection order options, say, well, there are protection order options, here they are, take a look, what do you want to do? And they say, what do you think I should do? All you can reiterate is what the orders state. And they have to come to that decision themselves. And they may still think, you know what, my kid is the exception. I know they don't qualify by age, but my Brian is so special, and I know if a judge hears him or sees him, he's going to grant him some relief. And you're thinking to yourself, that ain't going to happen. You can think that all you want, but you can't say that to Brian's mom. Because, again, people can file for whatever they want, and that is their right, and we can't stop them. Again, the only individual that can make that decision is a judge who rules in their case. So the next two slides are actually, this is a slide that you will find on PCADV's homepage, pcadv.org. As I said earlier, there are 60 domestic violence programs located throughout the state that serve all 67 counties. If you're not attached to a domestic violence program, but you're working with victims, you want to make sure you get familiar with the program in your county, because they are a wonderful resource, not only for you and your victims, but to deal with these issues that these programs have been dealing with for a long time. Or if you're working with a victim that fled from another county and they're going to return home and they say, well, where can I get help? All you have to do is click on any county on the map, and the name and phone number of the domestic violence agency will pop up. So it's very easy for you to find that resource. And again, you really want to use that resource when appropriate.
And same thing, on PCAR's website, which is pcar.org, we also have an interactive map where you can click on the county where you're located and find out which program provides services in your county. As Rachel mentioned, not only are these programs great resources for the victims you're working with, they're also great resources for you. You know, that way you can collaborate together on these types of cases and others. You can support each other in the work that you're doing, and it's just a really, I think protection orders in particular, but so much of the work that we do is so dependent on the other organizations and advocates working in our communities. So reach out to them, make those connections if you haven't already, or if that's not the type of environment where you are working, and learn from each other and help to support each other in your work to help victims. And real quickly, I just want to make a quick mention. I know that in the Foundational Academy, you all will hear more about this type of thing. But, doing this type of work is really challenging. It can be really, really difficult. And to make sure that you're taking care of yourselves when you're dealing with these very difficult cases. So, supporting each other, seeking help, making sure that you're taking the time to give yourself breaks and take those great vacations that you need to go on, so that you can be recharged and able to really support victims in the best way possible.
Well, I just flew by the question slide, but you guys have had great questions throughout the webinar, so now that we are at the end, we absolutely are here to answer any questions you may have. As you can see, I put up the slide that has my contact information as well as Karen's, and Karen and I and our organizations are always available to answer questions and provide any resources you might need. So there's a question. Can someone apply for a protection order in a state or county that is not where the abuse took place? That's a great question. When it comes to filing for PFAs, not PSVIs, absolutely yes. The PFA Act understands that a victim of domestic violence oftentimes has to flee wherever they're living to escape the abuse and to be safer. So if you have a victim that is residing in Dauphin County with their abuser, an act of abuse takes place in Dauphin County and the victim flees and goes to live with her mom, who lives in Lebanon County, she can absolutely file for that PFA in Lebanon County, even though the actual abuse occurred in Dauphin County. Now, that's not the way the law is written for the Protection of Victims of Sexual Violence or Intimidation Act. That law requires the victim to file in the county where the abuse occurred. But again, it's very different if you're talking about domestic violence. So the victim can file wherever they might end up as a result of escaping the abuse. That's a great question.
And again, we can't stop people from filing for orders, so they can, I mean, you can explain the law to them, but if they want to file, they get to file.
Right. So we'll give you guys another minute or two just to see if anyone has any last questions. Again, Karen and I are absolutely always available to answer questions or talk things through, so please either call us or send us an email.
And please don't, this is Donna, just don't log off because there's going to be a link that pops up for you to do an evaluation of the training.
And I just want to thank you all for participating today. And again, you know, don't ever hesitate to reach out to me, to Rachel, because we learn more by hearing from all of you. So in order to help us and our organizations to really have a handle on the statewide perspective, it's really helpful if you share with us what's happening in your communities, whether they're successes or challenges. We'd love to hear from you.
And it's also important to remember that for Karen and I, we used to be exactly where you are. Both of us assisted and represented victims for many years, so we absolutely understand where you are.
We just had a question pop up where there was an adult that had been sexually abused by a 17-year-old, and the question was asking if any of these orders would be appropriate. Well, if there was sexual abuse that occurred, you know, as defined, you know, by the Act, by the Crimes Code under sexual violence, that would a sexual violence protection order could absolutely be appropriate, because the only order where age matters is the protection from intimidation order. So for a PFA or sexual violence protection order, either person can be any age. It really relates back to what the behaviors were and, you know, the risk of harm that that person is at. So age only matters for the protection from intimidation order.
And it's the same with the PFA. So in this scenario, let's say you had a 17-year-old cousin who sexually assaulted their other adult cousin. That adult cousin would absolutely be able to file for a PFA against that 17-year-old. As Karen said, the only time age matters is when you're talking about filing for a protection from intimidation order. Great. Well, I don't think there are any other questions unless one pops up. And we thank you again for participating in today's webinar. And I think Donna just needs to mention a few housekeeping matters.
No, actually, I don't really have anything else to say. I just would ask you to please complete the evaluations, and I will email you your certificate. Okay. So, Mike, if you could put up the evaluation, that would be great.